The phrase rule of law started to be used widely at the end of the 19th century within the work of English jurist Albert Venn Dicey. In the tradition that Dicey seeded, rule of law is used to describe a legal system in good working order. It is an explicitly evaluative term. It thus carries a moral charge. To be more precise, it reflects a judgment on how a legal system ideally would work and what it ideally should do. As such, the English language tradition of thinking about the rule of law overlaps with, while also taking distinct turns from, several other intellectual traditions. These include similar traditions in German thinking about the Rechtsstaat and French reflection on l'état de droit. This short book isolates and examines the genealogy of English language debate centered around the phrase rule of law. It addresses the distinctive ethical contribution offered by this phrase, largely setting aside how the same questions are framed and resolved in other traditions. Is there a common thread to the rule of law tradition beyond its ethical character? A core rule of law aspiration is that law can and should constrain how power is flexed, especially by the state. Yet how or when this happens is disputed and murky. Disagreement persists, for example, as to whether the rule of law is a matter of how law is used or why it is deployed. People with profoundly different moral commitments and beliefs can and do hoist the rule of law as a banner or swing it as a cudgel. Such disagreements, however, do not undermine the rule of law's relevance. To the contrary, they show that the rule of law can still be deployed as a way of framing and evaluating the substantive moral ends of law and legal systems. It is, in that sense, akin to the word justice, which offers an indispensable, and so necessarily vague, platform for making moral claims of society at large. One reason for disagreement is that the law itself is a very complex social practice. A modern legal system is inevitably a blend of statutes, a common law created by judges in lines of cases, regulations issued by the executive, and widely shared precepts and social practices. The rule of law might pick out only some of these modalities as particularly important. Law is also usually viewed as distinct and autonomous from other bodies of rules, such as social mores or religious dictates. At the same time, it is supposed to be comprehensive in reach and supreme over the other bodies of rules within a given nation. A modern legal system also has many moving parts. There are formal legal institutions, such as legislatures, courts, and officials. There are received wisdoms and age-old customs. And there is often tacit knowledge about the way things should be done. All these can be assembled in different ways. But a common assumption in talk of the rule of law is the existence of a single standard, applicable across all this variation. Is that demanding assumption, which often goes unnoticed and undefended, viable though? Or do different legal systems, which are made up of different sorts of institutions, embody different versions of the rule of law?